On September 2nd, 2025, officers of the Covington Police Department observed Covington resident Martell Hunter riding his bicycle through a parking lot in the early morning hours. The officers initiated a stop based on their observation that Mr. Hunter's bicycle light had allegedly not been activated, in violation of Section 14020 of Title 601 of the Kentucky Administrative Regulations, which requires a front bicycle light visible for at least 500 feet during nighttime hours. Under Section 189.99021 of the Kentucky Revised Statutes, a violation of that regulation carries a fine of no less than $10 and no more than $100. The interaction that followed was captured on officer body-worn camera.
You just step on the just have a seat.
I ain't sitting on no ground over riding no bike.
Yeah, so yeah, I do need you to sit down, okay?
I'm not sitting, I got a broken hip. I'm not sitting on no ground over no bike.
Okay, so I need you to sit down, okay?
Just a bike light, dude.
It's not
sit down.
My name's Martell Hunter. Can't you turn your body cam on?
It's on.
Alright, my name's Martell Hunter. I live right down 34th Street. Just came out to get some cigarettes. We're going back home.
So here's the deal. So stop you because you're light. So I'm asking you nicely to sit down. That's all I'm asking.
I'm not going anywhere. I'm holding a bike. Yeah, can't you just run my name?
I'll hold the bike.
No, I don't want you to touch my property.
Dude,
you're making this, my property.
This way harder.
You're making the simple. A simple.
Go across the street. How can I?
Do you have your ID? Do you have your ID?
Maybe.
No? Okay. I'm gonna ask you again to sit down. So I can.
Come on, man. Why? I'm too old to be sitting on the ground over a bike. All I did was come get some cigarettes, man. I just woke up. I'm sorry the light wasn't on. It shorts out. I mean, I don't know what you're making
a
big.
I'm more worried about you not listening to what I'm going to do. So sit down, okay? That's all I'm asking you to do. Sit down.
Man,
I'm not being serious. Sit down.
Nah, why you touching me? I'm gonna sit and I'm gonna sue you. Can I have your name and badge number? I'm gonna sue y'all for this. Cause I ain't doing it. I shouldn't be on the ground over a light on the bike. All right. I'm glad y'all doing what y'all want to do. I'm gonna sit right here. I don't even want to talk. Can I have a supervisor?
Yeah, you can after we get your information.
Oh, I want a supervisor.
What's your first name?
I want a supervisor. I am
Get your name first.
I don't have to talk. I asked for a supervisor.
You're making this way more than what
I want a supervisor. I didn't do anything.
Listen.
I sat down on the ground like you asked me to. Can I have a supervisor?
Hey, listen.
No, sir.
Listen.
No, sir. No, sir.
Here, let's start over.
No, sir. No, sir. No, sir. I feel like I'm being harassed by the Ku Klux Klan.
Listen, sir.
No, sir. No, sir. I want a supervisor. I want to talk to somebody who's professional who would have made me get on the ground over a bike.
Stop talking for a second.
No, I want a supervisor.
I just need your name.
I gave it to you. I want a supervisor.
You did not give me your name. What's your first
name?
I did
when before you made me sit down. I gave you my name. I want a supervisor. We're not playing these games. I'm allowed to have a supervisor. It's my right to have a supervisor.
All right. All right, sir, you're going to go ahead and be detained for the moment.
That's fine.
All right. Just stand up.
You still ain't give me your name and badge number.
Officer Meadows, 0392.
And I'm being detained over a light on the bike.
Yes. For safety.
For safety.
Yes. I don't know what's in your pockets. You have a jacket. I don't know what's all in your pockets.
You putting this cup on over my jacket. You cutting my circulation out.
Dude, you have anything on you that's gonna stick?
I just come from the store. No, I got a condom and some cigarettes and some cigars.
Pretty much.
Can you pull my coat out my handcuffs?
Hold on.
attitude for this.
Officer Meadows handcuffs Mr. Hunter and pats him down, citing safety concerns based on the fact that Mr. Hunter was wearing a jacket. Now, because bicycles qualify as vehicles under Kentucky law, this encounter constitutes a traffic stop, and the same constitutional framework that governs vehicular traffic stops applies here. As the United States Supreme Court held in the 1968 case of Terry v. Ohio, a pat-down of an individual's outer clothing is permissible only where an officer can point to specific and articulable facts that would warrant a reasonably prudent person in the belief that the suspect is armed and presently dangerous. A generalized concern for officer safety standing alone is insufficient. Rather, the officer must be able to articulate why the particular individual posed a threat. In the 1977 case of Pennsylvania v. Mims, the Supreme Court confirmed that this standard applies equally in the traffic stop context, holding that the Terry framework controls whether a frisk conducted during a lawful traffic stop passes constitutional muster. While applying that standard here, Officer Meadows cited a single justification for the frisk, that Mr. Hunter was wearing a jacket and he did not know what was in the pockets. Notably, he did not identify any visible bulges or other facts that would suggest that Mr. Hunter was armed and dangerous. The remaining circumstances offer little additional support for the lawfulness of the frisk. Mr. Hunter did identify himself by name when originally approached by the officers, which cuts against any suggestion of evasiveness created by his later refusal to repeat his name. Likewise, his initial reluctance to sit on the ground was accompanied by a specific physical explanation, an injured hip, and he ultimately complied with the directive. Because wearing a jacket, verbal protest, and physical hesitation rooted in a medical condition do not suggest that a person is armed and dangerous, a court would likely find that the facts available to Officer Meadows at the moment of the frisk fell short of the specific and articulable standard that the Terry case requires.
All right, I'm gonna help you sit back down, okay?
I want you to take my coat sleeve out my handcuffs.
Sit down, dude.
I got a broken hip.
I'm helping you sit down. Here you go.
All right, I'm telling you, watch, y'all gonna get sued. All
right.
I hope this is worth it.
Let's try again.
No, I want a supervisor.
I never told you no to a supervisor.
All
I don't
right,
care
well,
to get you a
I'm
supervisor.
not- all right,
Listen,
well, I
my
just want a
supervisor has to know who I'm talking to.
Martell.
Martel, thank you. M-A-R-T-E-L?
I want a supervisor.
M-A-R-T-E-L?
I want a supervisor.
Can you watch them for a second?
Yeah.
Can I ask you a question?
Who's the supervisor?
Contract 83.
82, go ahead.
Sir, this guy was stopped inside requesting your presence.
Come to headquarters.
Good work for sure. What's his name? Montez?
Martel Hunter.
Martell. So the supervisor's not going to come down. You can go up to headquarters and talk to him once we get done here, okay?
I just want all y'all cards when I get done. sitting here in pain. Y'all slammed me to the ground and I told y'all I got a broken hip. Tyrants. They hate black people. Oh, it's too dark. I can't see. I can't see the spot. Look at the coon. He's moving fast. Position is making my leg twitch. Y'all don't care about me being like this over a bike light.
Mr. Hunter states that the handcuffed position that he's being detained in is causing his leg to twitch, presumably due to his hip injury. Now, although the underlying stop was likely lawful due to the observed traffic violation, the fact that the initiation of a seizure is lawful does not insulate every subsequent action that an officer takes during the stop from constitutional scrutiny. As the Supreme Court held in the 2005 case of Illinois v. Caballes, an initially lawful stop may nevertheless encroach on an individual's Fourth Amendment rights if its manner of execution unreasonably infringes interests that are protected by the Constitution. Accordingly, a court could still conclude that Mr. Hunter's detention violated the Fourth Amendment if it found that handcuffing him under these particular circumstances was an unreasonable manner of executing that stop. In the 2022 case of Hamilton v. Franklin, Tennessee, the U.S. District Court for the Middle District of Tennessee, a federal court within the Sixth Circuit, which also includes Kentucky, held that handcuffing during a traffic stop can be constitutionally permissible if an officer can point to specific circumstances justifying the precaution as a safety measure. In reaching this conclusion, the court relied on the Sixth Circuit Court of Appeals determination in the 2007 case of United States v. Atchley that non-compliant, agitated, or combative behavior during a seizure can justify handcuffing, even when a detainee is not being placed under arrest. Mr. Hunter, while vocal in his objections, identified himself, communicated a physical limitation, and ultimately complied with officer directives. Accordingly, a court applying this precedent could determine that the decision to handcuff Mr. Hunter was unreasonable under this set of circumstances.
I can see if I assaulted somebody, if I hit somebody on my bike and kept going. Forward. I'm bored, I'm straight. Double call. My stepdad right there, he see y'all too. Hope y'all enjoyed yourself. What's taking so long? I've been here over 15 minutes. This is a Terry stop.
So it says here you're not going to be able to put a vehicle information in because there's no registration for it.
So it's not a traffic stop.
I mean, you can put in there you get traffic stop on a moped.
So I just click no. I click the traffic stop for this and just.
You gotta do your court date.
What am I waiting on?
For us to finish your paperwork.
It'll take 20 minutes to give me a ticket for a bike. I gotta sit here in pain over a ticket.
Mr. Hunter protests how long he's being required to wait while the officers issue his citation. As the Supreme Court held in the 1983 case of Florida v. Royer, an investigative detention must be temporary and last no longer than is necessary to effectuate the purpose of the stop. The court reaffirmed and sharpened this principle in the 2015 case of Rodriguez v. United States, holding that a traffic stop can become unlawful if it is prolonged beyond the time reasonably required to complete the mission of issuing a ticket, which includes tasks such as checking the driver's license, determining whether there are outstanding warrants, and inspecting the vehicle's registration and proof of insurance. Here, Mr. Hunter had been detained for approximately 15 minutes at the time that he expressed opposition to the length of the detention. Under the framework established in the Royer and Rodriguez cases, a court would likely find that the detention did not exceed the range of time reasonably necessary to complete the administrative tasks associated with the traffic stop, and that the duration of the stop alone did not constitute a Fourth Amendment violation. However, as we discussed earlier in this episode, the more substantial constitutional questions raised by this encounter concern not how long Mr. Hunter was detained, but the manner in which that detention was carried out.
I'm gonna get every piece of footage y'all got. I'm telling you, I'm putting it right on the internet. Every piece of footage y'all got is going on the internet.
Get him up real quick.
I don't want to be touched. I can stand up on my own.
We're gonna help you up.
I don't want your help. I just told you don't touch me. I got a broken hip and a broken back. Don't touch me. You're hurting me.
Right. Put your legs up towards your chest.
I can get up on my own. Am I still detained?
Get up.
Yeah, thank you. Have some respect. I don't want you touching me.
Just making sure you do the call.
All right, I'm okay. I can fall all I want to. I want y'all cards. Get y'all cards out.
All my information.
Get your card out. You can't deny me what I have the legal right to.
So you're going to be cited for no license device.
That's cool. That's fine. That's fine.
You have a court date on
That's fine.
9:30 a.m.
That's fine.
30 Madison Avenue.
That's fine.
Any instructions
That's fine.
that you may need is going to be on the back, but also there's
That's fine.
instructions on what you need to do.
That's fine.
Does that make sense?
That's fine. I'm not signing anything.
Well, you do have to go to court.
You have to sign it. That's the back side.
Yeah, that's the one you put on over my coat. Can I have y'all card?
I'll give you mine.
Yeah, so you detain me, I'm allowed to have your card.
Easy, man.
You got his ticket. That's everything you need.
Can I have your card?
I'll give you my name and badge number.
You gonna write it down? I should have to remember
It's
it.
Officer Jansen, 298.
I can't remember that. I'm old.
By policy,
Can you write it down, please?
Well, I told you it. I don't have to write it down. There's your citation. Make sure you go to court.
Every one of y'all getting sued. Okay. Now, I'm talking to my stepdad. You go back. You a server.
Mr. Hunter was issued a citation and released. I was unable to find any public court records confirming the outcome of his case. On January 27, 2026, Mr. Hunter was stopped again by the Covington Police Department, this time for allegedly jaywalking on a snow-covered road with obstructed sidewalks. During that stop, Mr. Hunter was again handcuffed, searched, and this time transported to jail, where he was held for several hours before being released. Overall, the Covington officers get an F for conducting a pat-down frisk without specific and articulable facts supporting a reasonable belief that Mr. Hunter was armed and dangerous, handcuffing a compliant detainee without circumstances justifying that level of restraint, and demonstrating ongoing indifference to Mr. Hunter's repeatedly communicated physical distress. The established standard for a lawful frisk requires officers to act on more than just a generalized safety concern. And here, Officer Meadows informed Mr. Hunter that he was patting him down because he was wearing a jacket worn in the early morning hours of September is hardly suspicious, and it falls well short of establishing that an individual is armed and dangerous. The decision to handcuff Mr. Hunter is likewise difficult to defend. While courts have recognized that officers may use restraints during a traffic stop detention where necessary for officer safety, Mr. Hunter's conduct gave no indication that he posed a flight or safety risk. Finally, despite the fact that Mr. Hunter communicated his hip injury from the outset, the officers made no adjustment to accommodate him or relieve his discomfort, opting instead to simply ignore his complaints. What makes the officers' conduct even more troubling is that Mr. Hunter was stopped for riding a bicycle without a light, a minor traffic violation punishable by a maximum fine of $100. This interaction highlights how the reflexive application of investigative and restraint authority, untethered from the severity of the underlying offense and indifferent to the physical condition of the individual being detained, can transform even the most minor of traffic stops into a serious constitutional concern. Now, Mr. Hunter gets a B+ for physically complying with officer directives despite documented physical pain, clearly and consistently communicating his physical limitations throughout the encounter, and identifying himself by name at the outset of the stop. When directed to sit on the ground, Mr. Hunter objected verbally and explained that he had a broken hip, which is a legitimate and specific reason for his reluctance. And when the officers refused to relent, he ultimately complied despite the pain. And although his initial identification was prompt and specific, his refusal to repeat his name when asked again, and his increasingly combative verbal exchanges with the officers, it introduced additional friction into an encounter that the officers had already pushed well beyond what the circumstances warranted. Declining to re-identify, while understandable given his frustration with the officers, was not an approach that best served Mr. Hunter's interests in that moment, and escalating an encounter verbally can create indicators of non-compliance that officers can point to when justifying more intrusive measures. That said, Mr. Hunter's sustained physical compliance in the face of genuine pain reflects a measured and legally sound response to a difficult situation. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out Audit the Court if you're interested in exploring the legal nuance beyond the body cam.